cry of the living folk is gender justice. Gender justice is that means that women have to be given equal importance. Women have to be given opportunities in all the departments, in all the spheres of activity, and they should not be discriminated. In this regard, I will tell you why this gender justice also came into play. Once there's a conflict between Lord Shiva and Shakti as to who is superior, then there was a compromise arrived at where they said Lord Shiva is described as Ardhanarishwara. That is, the front part of it is Shiva and the back part of it is Shakti. Shiva doesn't exist without Shakti and Shakti doesn't exist without Shiva. In the same way, as far as the legal subject is concerned, no one can claim himself to be a master. Today, when we studied in 72, we did not have so many subjects. We didn't have so many opportunity to go to the internet, Google and all. Google, internet and all are all a modern invention. We had to only depend on the books and nothing but books. Today, you people are fortunate. Just log on to Google, you get everything, including the case law. But please remember, I don't say Google is perfect. There's misleading information also given in Google. So, before we start the subject, we go through the Hindu Succession Act of 1956. The Hindu Succession Act was mostly aimed at removing the anomalies and injustice done to women. Previously, we remember, even in mythology, of course, people may not subscribe to my view, Sita underwent lot of suffering because of various reasons. The question is, Sita was always considered a woman, but at all times, Sita said, I am the consort of Lord Rama. And she remained loyal to Lord Rama till her lifetime. In the same way, what happened was, before the 1956 enactment, women were discriminated as far as gents are concerned. Women had no opportunity, and women were deprived of so many opportunities, employment potential, then placements in various organizations, and so on and so forth. Then it led to the women movement, whereby they said, we are no way inferior to men. Please remember, all of us, whether you like it or not, most of you are married also. We have to depend upon our consort for the purpose of getting guidance. But sometimes what happens is the male chauvinism does not allow us to recognize the importance of woman. Woman is supposed to be the Shakti and embodiment of Shakti. And without a woman, a man cannot stay. Then what happened was the women folk went in protest and they wanted equal opportunities. And the union government at that time thought it necessary to pass an enactment called the Hindu Succession Act of 1956. But the background about it is, whenever you read a subject, you must please remember it's something like Aksharabhyasam. When a child is inculcated into education, the first thing is taught is Amma, Nana, and other things. So, in the same way, as far as the subject is concerned, you are inculcated or introduced into the subject by a clause called interpretation clause. Most of us don't read the interpretation clause, that is section 2 or section 3 of every enactment. It introduces the subject to you, it defines the various terminologies, various words that are used in the enactment. Unless you acquire mastery over the definitions, perhaps you cannot understand the subject better. In the same way, when you read English, first you are taught alphabets A to Z. Now numericals and all in Telugu also you are taught the alphabets. In the same way, as far as every subject is concerned, the purport of the subject, the interpretation of the subject, the various words, various terminologies which are introduced in the definition clause. The first definition which is given is, what do you mean by succession? Succession means where a person is deceased, he expires, leaving behind sons and daughters and his widow. How the property has to devolve on these legal heads. Then the subject which you have to refer is the Hindu Succession Act, how it goes. So succession normally means that is how you succeed to the property of a disease is what is called succession. The corresponding word used in the Muslim law is inheritance. It is not called Muslim law of succession, but it's called Muslim law of inheritance. But as far as Hindu law is concerned, it is called the Hindu law of succession. Then the second word that is used is cognate. Cognate. Cognate means the legal heirs through our husband are called cognates. Then agnates. Agnates means the legal heirs who are connected with you through your wife or through a female group are called agnates. Then normally as far as succession is concerned, preference is given to the cognates. That is from your husband's side, the property has to develop. Then the character of a property is two things. One is called proportionary or ancestral, and another is called self-acquired or what is called in Telugu ancestral or proportionary is called purvajitam. As far as self-acquired is concerned, it is called swarjitam. So the question is, first and foremost, as an advocate, you must find out as to what are the whether it is a co-partner property, ancestral property, or a self-acquired property. So to know that, you will have to refer to the cognates and agnates. Cognates are the legal heirs for your husband's side, and agnates are people who are related to your wife's side. They are called cognates and agnates. When the question of succession comes, the question of cognates are normally preferred to the agnates. That is, they get the first preference as far as succession is concerned. Then what do you mean by proportionary property? Proportionary property means a property which is coming from ancestors or forefathers and you belong to that particular descendant, you are the descendants of that particular family and you are, it is called a proportionary property. Corresponding Muslim law is called matruka property. Matruka property means a property that is heritable. It is coming from ancestors. That is called a matruka property. That is not going to the Muslim law now. Then we come to what is called the line of succession as far as Hindus are concerned. As far as Hindus are concerned, it is governed by Section 8 and Section 6 of the Hindu Succession Act, which deals with the lines of succession. Hindu law is divided into three parts: Class 1, Class 2, Class 3. We'll deal with each one of them separately. Class 1, you have got son, daughter, son's son, son's daughter, daughter's daughter, daughter's son, so on and so forth. Class 2, mother, father, brother, and other people. So class 2 comes into operation only when class 1 is not available, not otherwise. In this regard, I would try to cite you one personal case which I dealt with on behalf of a daughter-in-law of the house. The daughter-in-law lost her husband, and her husband was employed in the State Bank of India. And as the question of employment is concerned, the daughter-in-law was given employment in the SBI on humanitarian grounds. Then daughter-in-law subsequently got remarried, and the mother-in-law got vexed, and she said, "I am also a class one here, because being the mother of the disease." Then, as far as the State Bank of India regulations are concerned, there are separate rules which govern State Bank of India. Here, I was at a wit's end. If you see, mother filed a suit saying that she is a class one here and she is entitled to half the terminal benefits of our deceased son. The daughter-in-law said that I am entitled to the absolute terminal benefits irrespective of my getting married or not getting married. Then the question of interpretation of the word family had come into the picture. As far as the State Bank of India Provident Fund rules or the terminal benefits are concerned, the word family is defined as saying that spouse or spouses, children. That's all. As far as mother is concerned, mother is excluded from the definition of the word family. In that particular case, what happened was before marriage, the nomination was made in the name of the mother. Please remember, we acquire everything by birth. When we are born, we don't have a spouse. No one says I'm already married in the previous birth to so girl. They'll slipper you also if you say that. The question is, family is acquired later. In that particular case, the Provident Fund rules of the State Bank of India says the word family is defined as spouse or spouses and children. Mother is excluded. Then I interpreted it for the State Bank by saying, sir, once a person gets married, he acquires a spouse, he gets children also. So even if the nomination is in the name of the mother, it gets wiped out by subsequent marriage or acquiring a spouse. So that is the reason I could get through it by saying mother is not a legal heir. Does not come within the definition of the word family. The question is, even if the nomination stands in the name of the mother, it gets automatically wiped out once a person acquires a family. Of course, that matter went up to the Supreme Court, and where the Supreme Court also concurred with me by saying the word family means spouse and spouses and children alone. Mother is excluded. But if you see the Hindu Succession Act, mother also is a class one here. I felt sorry for the mother. The question is, జన్మ ఇచ్చేసి పుట్టించేసి నాకేం లేదంటే the question is, it is absolutely ridiculous. But that is the law. Please remember, that's why they say చట్టానికి కళ్ళు లేవు. Law does not have eyes. It cannot see. That's the reason if you see the statue of justice, there the I mean cloth is tied on the eyes of the goddess. The question is, we are only చట్టానికి కళ్ళు లేవు అంతా కాను. The question is, and we are only responsible for it, giving different interpretations and different judgments are coming. Sometimes 3D judgments are also coming. So here, ultimately the daughter-in-law succeeded, the bank succeeded by saying the word family means spouse and spouses and children. Mother is excluded for the purpose of succession of her son's property, even son's terminal benefits, even though the nomination may be there before the marriage of the son to the daughter-in-law. That is the interpretation given in the State Bank of India Provident Fund rules. Are you able to follow, please? At that stage, when that case had come up, we didn't have the Google, we didn't have the internet, but I had to get that book from Calcutta and then interpret the particular provision. So that is how it is done. Here, the question is class one: son, daughter, son's son, son's daughter, daughter's son, daughter's daughter, then predeceased son, so on and so forth. That is a class one heads. Class two is father, mother, and then you have got what is called brother, so on and so forth. Then class 3, of course, is a different thing. So this has been specified and laid down in section 8 of the Hindu Succession Act. Are you able to follow, please? Then we come to gender justice. In gender justice, we must understand the meaning of the word reversioner. Reversioner. Here, if the lady has children, there's no problem at all. But unfortunately, if the lady doesn't have issues, how the succession has to go? The son of the last male holder, please emphasize the word, son of the last male holder, that is the husband's brother's son or brother's daughter, comes into the position of a reversion. And the hapless woman cannot alienate the property, cannot transfer the property, she can enjoy the property so long as she is alive. Only under two circumstances she can alienate it. One is for a legal necessity. After all, why do we eat, sir? To keep our body and soul together. So the question is, even a woman requires money. Vitamin M is required by everyone. So for that purpose, she can alienate the property if it's a pressing legal necessity. Second instance is when she has got debts of her deceased husband to be discharged, then she can alienate the property. Under those two circumstances, alienation is permissible. But if those two circumstances are not present, not prevalent, then in that case, the reversioner has got a right of after the widow's death to bring a suit to set aside alienations, saying that it's not with legal necessity that the alienation has been made. Are you able to follow, please? But women protested against this particular proposition, and this led to the saying that as far as women are concerned, women are also equal as far as gents are concerned, and that is the reason why Section 14 of the Hindu Succession Act was introduced, whereby they abolished the institution of reversioners and said when a property stands in the name of the woman or she has succeeded to the property through her husband, the question is it's her absolute property, nothing else. The question is she can enjoy it, she can do what she wants, she can alienate the property, she can encumber the property, she can create charges over the property, or so on and so forth. So that was a drastic amendment that was brought by introduction of Section 14. Now, a woman's estate under Section 14, when the property stands in the name of a woman, it's her absolute property. Right? I tell you so. Reversioner is the son of the last male holder. That means your husband's brother is supposed to be brother or brother's son is supposed to be the reversioner. Or the husband's brother's son or brother's daughter is supposed to be the reversioner. If you don't have issues, of course. If the lady does not have issues, the son of the last male holder is entitled to the property. That means, అంటే ours is a patriarchal society. We are more tilted towards the men rather than women. Am I making myself clear to you, please? But in Tamil Nadu, of course, I'm not saying about Tamil Nadu because I belong to that place. In Tamil Nadu, when you say Mr. So-and-so, you can give your mother's name also as son of Srimati so-and-so. But here in our places, we have to describe ourselves as son of so-and-so. Here, mother's name will not be introduced. But in Tamil Nadu and some places, mother's name also can be shown as the as your address or as your description. Then what happened was, before going to the women's rights, we go into one more aspect. I'll come to women's rights later. Here, there was one thing called survivorship. Survivorship means, suppose, let us say, a person leaves behind a property, bequeathing it to two or three sons, let us say. Then let us say two sons expire, one son is alive, and under the doctrine of survivorship, it is said, whatever property is left behind by the deceased doesn't go by succession. It goes to the survivor, that is the third son who is alive. It does not go to the legal heirs or the first two sons who are dead and gone. Are you able to follow, please? So, doctrine of survivorship means if a person has two sons, one of the son expires, who is entitled to succeed to the property. If he expires, the second son who is alive, second son who is the survivor, the entire property will go to the survivor and not to the legal heirs of the deceased son. Am I making myself clear to you, please? That was the old law. But 1956 enactment abolished the doctrine of survivorship by saying property shall go only by succession and not by survivorship. So survivorship the doctrine of survivorship does not exist as on today in the statute book. Am I making myself clear to you, please? Again, I repeat, suppose a person has got two sons, and let us say one of the son expires. Normal understanding of all of you will be, sir, his legal heirs also will be entitled to succeed. No. Under the doctrine of survivorship, whichever son survives, he gets the entire property. Are you able to understand this? And this is based on what is called the law of primogeniture. P-R-E-M-O-G-E-N-A-T-U-R-E. Primogeniture means who, the eldest person, the person who survives, he alone gets the rights and does not go to the legal heirs of the deceased. That is called the law of primogeniture. All those things have been given a go by by the passing of the Hindu Succession Act of 1956. So, doctrine of survivorship has gone, women's limited estate has gone, reversioner has been abolished, and Section 14 has been introduced, whereby they say the estate vesting with a widow is an absolute estate, woman's estate is supposed to be an absolute estate, and there is no question of reversioner or limited interest. Am I making myself clear to you? Then we go to, before going to that, here we'll have to see the history of the Hindu Succession Act. Most of you are aware when the celluloid hero N.T. Ramarao came to power in 1984, he amended Section 8, introduced a new section called 8A, whereby they say this is only regarding ancestral property or compulsory property, whereby he said all women married after 28th February 1985, all women who are married after 28th February 1985, they get a right, a woman gets a right in respect of ancestral property or compulsory property. 8A says all female folks who are married after 28th February 1985, they get equal share along with our brothers in the ancestral property or compulsory property. That's how Section 8A was introduced, implemented from 28th February 1985. Then if you see, say after all, most of you, if you are aware of Constitution, there are three lists. List 1, List 2, List 3. List 1 is what is called the union list, where the central government can legislate on certain aspects. List 2 is what is called the state list, where the state can legislate and enact a law. List 3 is what is called concurrent list. Concurrent list is both the state can legislate and the central also can legislate. But as far as Hindu Succession Act is concerned, please don't be confused. It is a central enactment. It is not a state enactment. The Hindu Succession Act is a central enactment, and only the union government is empowered to introduce a law or amendment. But the state government took shelter under the concurrent list by saying, I can also legislate as far as that Hindu Succession Act is concerned. That's how Section 8A came into play. Section 8A says, all women married after 28th February 1985 get equal rights as far as compulsory property is concerned, ancestral property is concerned, they are equal as far as the male folks are concerned. But as far as the Swarjitam or what is called self-acquired property is concerned, there is absolutely no lacuna there. It says even a daughter is a class 1 here, specified in Section 8. She gets an equal share along with the brothers. Only difference is the compulsory property or what is called the ancestral property. Women get equal rights in ancestral property provided she is married after 28th February. Please note down the date. 28th February 1985. Then the central government did not want to get belittled. They said, we are also superior. We will also pass a law. They amended the Hindu Succession Act in 2005. If I am correct, somewhere in July 2005, whereby they introduced a new section called 29A. 29A of the Hindu Succession Act says that as far as a female child is concerned, by birth, she acquires a vested right in respect of the property and she is entitled for an equal share along with our brothers in the ancestral property or the compulsory property also. So equal rights were given to women as far as the 2005 amendment is concerned. That is Section 29A, read with Section 6 of the Hindu Succession Act. So the position is made very, very clear, saying that women have equal rights with the males. A sister, a daughter has got equal share along with our brothers. The question of there is no discrimination as far as women are concerned. Then you may ask me a question, sir, which will prevail? Section 8A shall prevail or 29A shall prevail? In my honest opinion, Section 29A alone prevails because It is a central enactment whereby women have been given conferred equal rights as far as ancestral property is concerned, compulsory property is concerned. I was the first person to write an article. The Pandora's box of dowry deaths have been opened by this amendment. I could tell you by experience, no daughter comes to me to write a plea or give a notice. The son-in-law comes and says, Sir, మా భార్య సైడ్ నుంచి ఒక నోటీస్ ఇవ్వండి సార్, మా మామ దగ్గర ఆస్తి చాలా ఉంది, నాకు కూడా వాట కావాలి, నాకంటే మా భార్య కూడా వాట, భార్య కంటే ఏంటి నాకంటే ఏంటి వాట కావాలి. సో ప్లీజ్ రిమెంబర్, sometimes what happens is we are not that independent as we pretend to be. డబ్బులు వస్తుంటే ఏ అడ్వకేట్ వద్దంటారండి, నోటీస్ ఒకటి పంపించి రేపు వచ్చింది అప్పుడు సెటిల్మెంట్ వస్తుంది అనమాట. అప్పుడు ఏ సార్
తర్వాత వాళ్ళందరికీ కూడా సక్సెషన్ ఇచ్చాడు సార్. కానీ సెంట్రల్ యాక్ట్ 2005 అమెండ్మెంట్ చేసింది, కానీ డేట్ మెన్షన్ చేసింది సార్. పర్టికులర్ నుంచి చేద్దామని
లేదు లేదు. ఐ కమ్ టు దట్. వాట్ యు ఆర్ రిఫరింగ్ వినీత్ శర్మాస్ కి వర్సెస్ రాకేష్ శర్మాస్ కి. ఐ కమ్ టు దట్. Here the question is, a female child by birth gets a vested right in respect of compulsory or ancestral property also is concerned. She is conferred equal rights along with the male folk. That was the amendment in 2005. 29A has been introduced and section 6 also has been amended, and it has been provided that the property devolves on the female child. As soon as it is born, it gets a vested right in respect to the property. So as far as Swarjitam is concerned, self-acquired is concerned, there's no problem at all, because the question is section 8 says even a daughter is a class 1 heir. The question is you cannot deprive her of her right in respect of self-acquired property. Then this particular question, I think posed by my friend, came into question in one of the leading cases, which is the leading case of the aspect. There's a case of Vinita Sharma versus Rakesh Sharma. That was decided by the Supreme Court in AAR 2020 Supreme Court. Of course, I don't remember the page. Kindly, even if you switch on to Google, you will get it. Vinita Sharma versus Rakesh Sharma. AAR 2020 Supreme Court. Here, the Supreme Court was asked to decide. I think most of you know, in every enactment you have the saving clause or you have a repeal clause, isn't it? Last clause. There they say, what I think my friend has asked me a question about 8A. The question is, it is implicitly presumed that the section 8A has almost gone into oblivion now. Section 8A is not implemented today. What is implemented today is only 29A. That was section 6 of the Hindu Succession Act, where in that Vinita Sharma's case versus Rakesh Sharma, initiated by the Supreme Court in AAR 2020 Supreme Court. Kindly note the page, please. I don't remember the page. Here the question arose, only I am giving the ratio of the judgment. The question arose whether 29A or the Hindu Succession Act conferring rights on a woman or conferring rights on a female child is prospective from the date of amendment or it is retrospective. The Supreme Court categorically said what is the spirit of section 29A is gender justice. The question is, as soon as a female child is born, she gets an equal right in respect of ancestral property or in respect of compulsory property also. It is not only prospective, but even prior to the amendment, it is applicable. Of course, they introduced a clause there. Unless and until it is proved and established that partition had already taken place, decree has already been passed, it cannot be annulled because of this amendment. But in case no suit is filed, in case no decree is passed, the question is, by birth, a woman gets an equal right as far as ancestral property or compulsory property is concerned. The Supreme Court categorically said that the amendment is not only prospective, but also retrospective. Retrospective is even prior to the amendment, it applies. My friend asked me a question regarding section 8A. That implicitly means retrospective. The question is, the old law, that is section 8A, has almost gone into oblivion now. So it is no more implementable. But of course, 8A suffered from some lapses also, sir. I could criticize it, not because I was anti-8A, but the question is, he wanted to confer rights on women. మొగది కాదు ఆడది కాదు అని చెప్పి అమెండ్మెంట్ ఇచ్చింది. What he said was all women married after 28 February 1985. What does it mean? What will happen to the woman after married prior to 1985? They don't get any rights in respect to the property. So the question is that suffers from that anomaly. That anomaly has now been removed by introduction of section 29A and section 6, which has been recast, whereby they say a female child by born, a female child as soon as it is born, gets a vested right in respect of ancestor or co-personally property laws. Right? So, yes, sir.
Sir, I have a question. See, there have been cases where I think they are referring to interstate succession, but there have been cases where the will deeds also were there, unregistered or registered will deeds. So, what in terms of those cases could also they have been challenged?
If the will deed is there, for your information, you cannot deprive the females of their right in respect to the property. The question is, she gets a vested right by birth. Even if a will deed is there you'll have to make a discrimination between ancestral and swarjitam. That is self-acquired property. Right? అంటే తెలుగులో అంటారు ఒక సామెత అత్త సొమ్ము అల్లుడు దానం చేస్తున్నాడని లేకపోతే నానాకి దుకాణమే లాలాకి ఫాతియా. The question is, you cannot sell a property or you cannot will away property over which you do not have any right. You must have a disposing capacity. The property should be within your disposing limits. Then alone you can do it. Even if a will is there, the woman can always challenge it by virtue of this 29 years. So, unless you have a compromise with the girls, pay them something, take a full settlement. The question is, you cannot deprive. The courts have gone to the extreme extent of saying, even if you take a document, అమ్మాయిలని మీరు అబలని మీరు డిప్రైవ్ చేయకూడదని చెప్పి రూలింగ్ జడ్జ్మెంట్స్ ఉంది. సో ద క్వశ్చన్ ఈస్ women's rights today is at a settled position that a woman gets equal rights as by birth along with her male folks equally in respect of not only partially property but also self-acquired. Don't bother about it. You are a class 1 here as far as section 8 is concerned. So Vinita Sharma's case, which is a landmark case on this particular women's rights, Vinita Sharma versus Rakesh Sharma, reported in AAR 2020 Supreme Court. Of course, the page number kindly note it, please. I've forgotten about it. So they said, Act is not only prospective, that is from that day, or even retrospective. Even prior to the amendment, it applies. That means 8A has now been diluted. 8A is no more applicable. That's what we have to understand.
Even registered will deeds can be challenged.
Challenged. మనం ఉన్నాం కాదండి ఛాలెంజ్ చేస్తాను. But one thing regarding, since you have raised the question of will, please remember, suppose you are a beneficiary under the will, being a son or whatever it is, you shall not sign that document as a witness. If you sign the document as a witness, you lose all the legacy that is given to you, because you know under section 17 or 18 of the Contracts Act, presumption of undue influence will always be presumed. So don't sign it. That's the reason why brothers take a chance with their daughters, their sisters, by saying, అది సంతకం పెట్టి మన అమ్మ సంతకం మన అమ్మదే కదా మా విల్లు మన నాన్నదే కదా. Please don't be guided by that. Don't sign as a attestor. Don't sign as a witness. And more so when you are an advocate, don't sign as an attestor. If you are an advocate, lot of complaints will be made against you. ఈ అడ్వకేట్ గారే రాయించారండి, క్వశ్చన్ ఇస్ మా వారు ఎవరు చెప్పలేదు, ఇది ఏదంతా తాపదం. ఈ సింహ అడ్వకేట్ అందుకంటే పాపాల భైరవులు అంటారు వకీలను. క్వశ్చన్ ఇస్, వీ కెన్ క్రియేట్ గ్రౌండ్స్, వీ కెన్ ఫ్యాబ్రికేట్ గ్రౌండ్స్, వీ కెన్ ఇంటర్ప్రిట్ ది గ్రౌండ్స్. అంటే 1 + 1 2 అని అంటారు, బట్ అడ్వకేట్ కెన్ మేక్ ఇట్ as 4. How we make it 4, that's your lookout. So the question is, Vinita Sharma's case versus Rakesh Sharma's case, it's a landmark case of the Supreme Court, reported in AR 2020 Supreme Court, whereby they say that the amendment is not only prospective, but it's also retrospective. Oral partition, the question is, please remember, writing unnakane chala problems ఉంటుంది. But unless the shares are settled and properties are already mutated, parties have acted on that, then the question it cannot be reopened again. But we can get it reopened because 29A is prospective as well as retrospective. That means it has been done against our will. The oral partition has been done.
Is it also applicable for gift deeds, sir?
Pardon?
Is it also applicable for gift deed? Let's say a forefather has gifted the property in favor of the son, can it also be challenged?
It is definitely be challenged because the forefather is not entitled to give away the entire property. The question it has to go by succession.
My son can my son can I have given it to my son. His son can be challenged to the ancestors.
No, he can't do it, sir. He can't do it so long as his father is alive. Sir,
His father is not
sir,
aware.
Release there.
he cannot do it, sir. Then we go to
Sir, what about Limitation Act? Already female child has knowledge about the distribution, partition, everything. But challenge after 20 years. Partition Act.
sir. As far as recovery of you see, you have raised a correct question, sir. As far as raising a question of your partition or whatever, fresh partition, 12 years period is mentioned within which you must file a suit to recover immovable property, whatever your share is. If you go beyond 12 years, you cannot challenge it.
They well known about the distribution.
Even if they know, at 12, within 12 years, you have to challenge. And I'm making myself clear.
You can come forward. You can come forward. Backseaters can come forward and you can have a
Yes.
better view.
Sir, ఇది retrospective,
మీరు ముందుకు రావచ్చు. Please come forward. Take your chairs, you can come forward. Be comfortable.
Contradict చేయదా సార్?
Article 21 of which subject?
Constitution.
Article 21 talks about personal liberty.
డిఫాక్టో పీరియడ్ ఫర్ ఎగ్జాంపుల్ డిఫాక్టో పీరియడ్ ఉంటుంది కదా సార్. లాకి అంత ముందు వరకు ఉన్న లానే అప్లికబుల్ అవుతుంది.
Uttarali, but one thing is this, your Hindu Succession Act does not repeal it, does not provide savings, does not provide anything to say that the old law is repealed. Old law is gone, abolished. The question is, if you don't have it there, you cannot lay down your own law. Are you able to understand this Vinita Sharma's case, please? Vinita Sharma's case, even now it has not been overruled, where they say it is prospective as well as retrospective. మీరు జత్యాలు ఉన్నారు కాబట్టి జత్యాలు ఇటువంటి కేసెస్ చాలా వస్తున్నాయి.
Sir, actually, the thing is, if the decision came in 2020, so it is retrospective. But the property got distributed in 1990. Let us say, example, just give an example. In 1990, property got distributed. So they might have sold it. So if they sell it, then there won't be.
See, if they sell it also, the right of the woman still survives. Unless you are able to establish that she has been a party to it, she has been a participant in that, she has got her share of the property by way of cash or whatever it is. Unless that is there. Then here I would like to, because you belong to the Vaishya community, here I will try to tell you one thing. In Vaishyas and Kammas, there is an institution called Pasupu Kunkuma. Pasupu Kunkuma is money that is given to a woman at the time of marriage towards marriage settlement is what is called Pasupu Kunkuma. Pasupu Kunkuma, yeah, Sridhar, whatever it is. The question is earlier, here another person also belongs to the Vaishya community. Here, as far as Sridhar is concerned or Pasupu Kunkuma is concerned, the earlier view is that it doesn't require stamping, it doesn't require registration. But please remember ఒక సామెత ఉంది మన దీంట్లో దేవుడు వరం ఇచ్చిన పూజారి అడ్డు వచ్చాడంట. సో ది క్వశ్చన్ మీరు చేసుకుంటే నేను ఎక్కడ అని చెప్పి గవర్నమెంట్ వేస్తాను అనమాట. సో ది క్వశ్చన్ ఇస్ నౌ ఈవెన్ ఫ్యామిలీ సెటిల్మెంట్స్ either now whatever it is, marriage settlements, Pasupu Kunkuma and all also has to be duly registered. It has to be on a properly stamped paper. And if you I just draw an analogy to your Registration Act also. You know, in 2001, the Registration Act was amended. 17B was introduced where they say all transactions relating to immobile property which creates rights, extinguishes rights, releases rights, relinquishes rights, or creates rights has to be properly stamped paper and it has to be duly registered. And it is implemented from 1/7/2001. Am I making myself clear to you?
Retrospective effect.
Exactly.
One more question. We talked about only about the son's share and assets. But what about the liability which is solely borne by the son? So that also has to be borne equally by the whatever.
It has to be deducted when allotting the share.
Correct. So that also.
Yeah, that is.
Retrospective
That has to be, that is a settlement of accounts, whatever is been spent. Yeah. Sir, are you able to understand this, please? Now coming to women's rights further.
Sir, one question. Sir. So father distributes his separate code property and unequal distributions. Suppose one son is
Given more and one son is given less.
and then someone given more share. Then Patria protesta. What is this? Father has can other son who get the less share can challenge.
It can definitely be done because a person who has been given less share has to be compensated by the person who has got
It
a,
was self-acquired.
even self-acquired also, larger share. He has to compensate the person who has got a lesser share with money, whatever is the money.
During his lifetime, he distributed the property. Basing on the capital tax.
It is on will basis what he is saying. Father gave will self-acquired property. That is not-
Even if he distributes it, nothing stops the other son by questioning it by saying he has got a lesser share than what you would have got.
Our has
Pardon? Sir, if you can come in front, it would be easy.
Sir, Villoche, come here.
Father life ఉన్న సరే ఇక్కడ పెట్టకండి తెలంగాణ అక్కడే ఉంటుంది
Then wire.
అది వాయిస్ క్లారిటీ లేదు వాయిస్
Yes. Now, when we are dealing with women's rights, we also have to deal with the present hot subject, where women are also demanding 33.5% reservation in jobs, in judicial appointments, then as far as the legislatures and parliament or the local bodies are concerned. Here, this has been a stillborn child. Though the bill was introduced long time back, it has got a stiff opposition. Why? Because there are two chief ministers who are opposing that bill. That is, one was the chief minister, then chief minister of UP, I think Mr. Mulayam Singh Yadav, and Lalu Prasad Yadav from Bihar. They said when we give 33.5% reservation to women, there should be reservation within reservations. That is, even in women's quota, there must be scheduled caste, scheduled tribe, backward class, A, B, C, and perhaps you are coming up to Z also. They should be Shivara Migle, the general community, all of Chippa. So ultimately, one or two posts will only be available to the general community people. That's why it is a stillborn child. Today, even now, the women are clamoring for 33.5% reservation in parliament, local bodies. There's nothing wrong in it. Because the question is, I feel by personal experience that women are better administrators than males. I'm not a woman chauvinist, but the question is, women have to be given their share. Women should not be deprived of their share. But unfortunately, what is happening is, because of the Supreme Court judgment saying that even a lady who has got only 1 day of practice or no practice at all, next day she can become a judge by appearing for the examination. We are seeing the plight of our judges also. I'm not for a moment decrying lady advocates, but the question is that if, in this profession to learn the alphabets, you must at least put in 3 years or 5 years of standing. You may be a gold medalist, but still practice is something different than what your theory is. You may be a gold medalist, etc. But to know the realities, how a practice has to be done, you will have to have experience. At a guru leni vidya, buddhi vidya antaru. The question is, you must join a senior, learn the alphabets, and then try to pick up the. But the question is, if you don't have standing, also you can become a judge. It's absolutely absurd. That has been criticized, but the Supreme Court has not annulled it. Bar Council of India is thinking in those terms that they must introduce a limit whereby 3 years or 5 years limit should be fixed. I just quote Justice Succession Reddy, who retired as Chief Justice of Chennai High Court also. He said that don't come to the High Court first. When you enroll yourself, first go to the lower court. Practice for 5 years and 10 years. Know the fundamentals, know the grassroots, then come to the High Court.
Don't come to the High Court just for asking for an adjournment, asking for a passover, or my senior on his legs or his hands in the next court, so on and so forth. First, learn the fundamentals from the lower court. Please remember, reading any number of books, reading any number of case law is not going to take you anywhere unless you are thrown into the ocean, thrown into the river, whether you swim or sink, it is your own headache. The question is, women's reservation in various categories are also now pending before the government. Perhaps now you've got the women empowerment also, I think, if I'm correct. The Mahila Commission also is there. Then you've got the women are given more rights today, and thanks to them, more women laws have come into operation. DVC under, PVC under, other under, DVC, then 498A, 304B, 306, Amendment of Suicide, so on and so forth. And now today, women entrepreneurs also, Dwakara group you've got here, self-help group. They can sell their products in a particular place. What they manufacture, they can sell it there. So these are all the rights and privileges that are given to women. Women are no more inferior to men. Please remember, women have to be given rights. Don't give them too many rights so that they may sit on your head. Already many people are feeling in the house and ఇంట్లో పిల్లి బయట పులి అంటారు. Question is, no doubt, women have got an important place in this world. They play a very important part and to guide the nation, and women's participation is required. That's why Section 14 has undergone a lot of amendments and a lot of changes. Then we come to the last section. Of course, I don't want to go exhaustively. Section 23 of the Succession Act, where the previous position was that as far as I think that question was asked by someone, as far as a dwelling house is concerned, woman is not a co-partner, she is not entitled to a share in the house property. But later on, after the Hindu Succession Act came into operation, what the Supreme Court and other courts have said is women get equal rights in respect of dwelling houses also is concerned. Are you able to understand this? So Section 23 is almost gone into oblivion. Then now we have the now when you are faced with a practical problem, how do you draft a suit? Normally, you file a suit, whether the civil side, by filing a document in the court called plaint. How a plaint has to be written. Of course, different people have got different ways of writing. No one is similar as far as draftsmanship is concerned. Drafting is an art as well as a science. It teaches you everything. And please remember, you have to learn by yourself. The question is, when you draft a suit, as far as succession is concerned, please remember there are people who are practicing on the trial side and people who are practicing on the appellate side also. As far as trial side is concerned, you require your client along with you across your table. You have to take proper instructions from the client. You have to take proper instructions from the client. And then also you try to look into the documents which support your case. And then as try to ascertain the facts from your client. And then put it in writing. When you are a newcomer to the profession, don't feel shy of writing 2 times or 3 times also, so that you get perfect. Most important is, of course, the other things I don't want to say, the address for service, that, this, and all. The next paragraph is very, very important. Brief facts of the case. There you say that the plaintiff is the son of so and so, so and so, so and so, and the plaintiff's father had so many sons, so many daughters. Then then you say that your father acquired the property through a particular sale deed, or it is acquired from ancestors. How your father came with the property, so on and so on. Then charitranta cheptaru. Then you say, I gave a legal notice that plaintiff issued a legal notice to the defendant, calling upon him to partition and divide the properties by beats and bounds, but the defendant did not give any reply, nor divided the property. Hence, I have no other alternative than filing the present suit. Then one more important thing you must remember in a succession suit when you write, the genealogical tree has to be clearly mentioned. How the property has come, how it has come from forefathers or it's come from your father, so on and so forth. Then after that, you allot the respective shares according to you, 1/4, 1/4, 1/4, 1/4, 1/4. Then after that, you say when the cause of action has accrued, you say cause of action for the suit arose on so and so date when the deceased died, leaving behind the properties mentioned in the schedule, and also on so and so date when the plaintiff through his legal notice called upon the defendant to divide and partition the property, and the defendant did not do so, hence the present suit. Then some of you was asking the question of limitation. As far as filing a suit for partition is concerned, it is 12 years. Recovery of immovable property or recovery of your share, it is 12 years period that is mentioned. When does it start, sir? It starts on the date of death of the deceased. After that, whatever steps you have taken from that period, the limitation starts. Normally, no one gives any importance to limitation, especially in a partition suit. Then you say jurisdiction, so on and so forth. Jurisdiction part of it, I'll also discuss it here. In CPC, I'll discuss it in detail. The question is, in Telugu, there is a saying, Sthanabalam. Sthanabalam is everyone is supposed to be a tiger or everyone is supposed to be a lion at the place where he or she resides. So the reason is, as a clever advocate, what you should do is, you've got about 6 properties, let us say. One property is at Guttur, one property is at Tenali, one property is at Hyderabad, one property is at Nalgonda, one property is at Khammam. You say, suppose, let us say, Mr. Vasantrao, he is a person practicing in Khammam. He says one of the properties is located at Khammam and therefore this court has got it. It's not necessary that all the properties should be located at one place. One of the properties is located at a particular place, that court will have jurisdiction. Of course, the other things you may say, when the question of division of shares comes, that's a different matter. So that's how you retain the client with you. You get your vitamin M also. Don't try to despair. That's the reason. ఏ ఆస్తులు చెప్పురా బాబు అని చెప్పేసి వాళ్ళ తెలిసి లిస్ట్ చేసుకుంటారు. హైదరాబాద్లో ఏం ప్రాపర్టీ ఉందని లేకపోతే ఖమ్మంలో ఏం ప్రాపర్టీ ఉందని రాస్తారు. దాంట్లో ఖమ్మం కోటి ఇది రైట్ ఉందని చెప్పి మీరు రాస్తారు. అది జ్యూరిస్డిక్షన్ పార్ట్.
In that case, whether the property is having a real value will be considered.
Value is not the consideration, sir. It is where it is located.
Even a small property is located.
Yes, even then. That is the reason, sir. That is the reason why you have to write a paragraph also. The plaintiff submits that there is no other suit pending in any court in respect of the same cause of action or any suit is pending. Are you able to understand this? Then in Rangareddy courts, especially in Hyderabad, there you have to add one paragraph also. The subject matter of the suit is not subject to section 89 of the Civil Procedure Code and it has not been referred to ADR. There is alternate dispute resolution and therefore the present suit is maintained.
Only Rangareddy.
Only Rangareddy. Here in Hyderabad they don't follow it. I mean, our city courts.
Rangareddy court they are insisting on.
Yeah.
Each court has that, so they
Yeah.
have to add that.
Sir, I will give you one proposition, sir. Here, as far as Hindu Succession Act is concerned, how do you proceed with the introduction part of it? How you draft a suit for partition letters, claiming your share? What are the documents you require for preparing a suit? Can you tell me what are the documents you insist on preparing a suit for partition in respect of Hindu Succession Act? Pardon? Legal certificate, no doubt, maybe
Family member letter.
family member certificates are not being accepted now. Yes, madam. Yes. Yes, you, I mean, being a big. You are a student, is it? Yeah. How do you? What are the documents you require for preparing a suit in respect of partition? Suppose you are appealing for a daughter or a female heir. What are the documents you require? Just be a bit loud. Takatu Patram. Yes.
Easy.
EC. Then Takatu Patram. Yes. Right. Right. Here, as far as the documents are concerned, first and foremost is you must try to establish the link, how it has come, how it has developed, who was the owner of the property, who was his son, from the son how it has come to the grandson, from the grandson how it has come to you, so on and so forth. So for that, you require your client along with you when you draft a suit. You don't draft it according to yourself because the facts are not only to your client. And if you don't want to file the original documents, take a certified copy of it, or where it is registered, file the certified copy. Why? Because one difficulty is if you file the original document, till the appeal period is over, you will not be given return the original document. So certified copy you file of the document, it's a registered document, it's a public document. Certified copy can definitely be filed. So first and foremost is when you start to write a plea, first try to get all the documents from your client. Study the documents clearly and try to find out what are the implications of that document, whether all the statutory requirements have been followed or not. And then the question is, then you start to write your plea. Yes. Then suppose let us say a suit is filed for partition. You file a suit for partition. Suppose your brother wants to alienate that property in order to see that you don't get your share. What are the steps you take to safeguard your interests?
You can
IA
come here.
should be filed.
You can come here and speak.
IA should be filed.
Because all the participants were sitting, definitely they will have a question. When it is a practical, it's a practical. It's not on the theoretical. It is just an introduction done by.
What is the application you file to safeguard your interests? I'm giving you the clue also.
IA should be filed.
Yes, madam. A miscellaneous application or what is called an IA or interlocutory application has to be filed, supported by an affidavit, and you file it under Order 39, Rule 1 and 2 CPC to say, pending the disposal of the suit, there shall be a temporary injunction restraining the respondent from alienating, encumbering, transferring, changing the nature of the property, so on and so forth. Are you able to understand? Then you sign in the petition, but your client signs in the affidavit, the first page as well as the second page. Then the person who swears to the fact in the affidavit or the sworn statement of fact is called the deponent. Who deposes to the fact in an affidavit is called a deponent. Are you able to understand, please? But if by any chance the person is a Muslim will not take oath. Muslim only affirms to the facts because taking oath under the Sharia is banned. So he says affirmant. So you say, I so and so, do hereby affirm and state as follows. Then you don't write the word deponent. You say affirmant. Then you don't say sworn. Affirmed and signed on this day of course. Then before we advocate or whatever it is. But being an advocate yourself, you shall not attest any document or you shall not attest any affidavit without the affidavit being identified by the person who is the advocate for that particular part. Because tomorrow you get into trouble. Suppose some other person signs. The question you get into trouble. That's the reason you play safe. So, in case you want to safeguard your interest, you file an application, miscellaneous application. It is called an IA or an interlocutory application, are supported by a petition and an affidavit stating all the true facts. Then the question is what you write in the affidavit. You need not write whatever is written in the plea. You can say the government made in the plea may be read as part and parcel of this affidavit. Are you able to understand this? Yes, these are all so many implications are there. then perhaps if you are aware of the Bible of civil practice, you got order 6 to rules of pleading. In fact, it is just plead and then prove, not prove and then plead. So whatever you have to state in the court, whatever you have to place before the court, don't hide any fact, don't suppress any fact, don't conceal any fact, mention it so that the other side is not taken by surprise. So all the facts in first person. Affidavit is normally drafted in first person. Your plaint is drafted in the third person. And the question is, you need not go into the entire gamut of the plaint. Brief facts of the plaint you can write. And you can always write saying that the government plaint in the plaint may be read as part and parcel of this affidavit. You need not repeat everything. But what you have to write is, the prayer clause you have to be very, very clear. In the plaint, I have seen some advocates writing, I therefore pray, the plaintiff therefore prays that this honorable court may be pleased to grant temporary injunctions. Please remember, suit is not filed for temporary injunctions. Suit is filed for perpetual injunctions. Your idea is filed for obtaining interim orders. In the interim orders, you say, I therefore pray that the respondent be directed not to alienate, encumber, or charge the suitable property pending disposal of the suit. My simplicity. There are some right? Then next procedure, what are the papers you file along with your trade in the Hindu Succession Act? See, the boundaries are not going to Samasya Undadandi because any registered document is there.
Basing on the furnace,
దానికి తాకట్టు పత్రం ఉంటుంది ఎన్కంబరెన్స్ సర్టిఫికేట్ ఎన్కంబరెన్స్ సర్టిఫికేట్ బౌండరీస్ అంటే మీ ప్రకారం ఏం బౌండరీస్ ఉందో తెలుపండి అంత క్వశ్చన్ సపోజ్ యూ నో దట్ your question is absolutely right. Suppose we say survey number 91. ఈ రోజుల్లో 91 by R, 91 by R, 91 by E, 91 by E, then whatever it is. Then the question survey number 91. Suppose the other side comes and says that it is not in 91, it is in survey number 91 by R. You amend your plate accordingly as per the admission made by it. But the question is boundaries తెలవకుండా సరిహద్దులు తెలవకుండా అందుకంటారు మీరు అడ్వకేట్గా మీరు సైట్ ఇన్స్పెక్షన్ చేయాలి. సైట్ ఇన్స్పెక్షన్ చేస్తే తూర్పులో ఏముంది, పడమట్లో ఏముంది, దక్షిణంలో ఏముంది, ఉత్తరంలో ఏముంది అని మీకు అక్కడ పేరు. బట్ సమ్టైమ్స్ ఇట్స్ ఇన్ అ క్లస్టర్. ఒకటే సర్వే నెంబర్ డిఫరెంట్ బౌండరీస్ ఉంది. సర్వే నెంబర్ 91 by R ఉందనుకోండి, part of survey number 91 by R, other part of 91 by R, then other part of who and survey number. So you'll have to go to the site and you can try to, don't try to expect your client to give you all information. Madam, are you able to follow this? The last, if you can come in front, it will help you, ma'am. Please come in front. Madam, are you able to follow, madam?
Sir, one question, sir. What is tenants in common in the giant tenants?
Tenants?
Giant tenants and tenants in common.
See, suppose there are 4 brothers, there are 4 brothers. They are in operation of different portions of the property. They are all entitled to a share. Then they are called joint tenants. Tenants in common అంటే అందరికీ సరి అయిన హక్కు ఉంటుంది. That's called tenants in common.
Sir, suppose the daughter doesn't know where are the properties are lying or the disease is smaller. So then how can she put it?
Sir, అంత అవలలు కాదండి ఈ రోజుల్లో లేడీస్.
Sir, you meant to say that చాలా మందికి ఉన్న సేమ్ ప్రాబ్లం డౌట్ ఉంది.
క్లెయిమ్ చేస్తామండి.
And suppose gentlemen,
లేదా చాలా మందికి ఉన్న డౌట్ ఏంటంటే తాత లాస్తుంది కానీ నాకు ప్రాపర్టీలు ఎక్కడ ఉన్నాయో తెలియదు.
whatever properties are known at a later stage, I'm prepared to add it to the
No. వాళ్ళందరూ జనరల్ క్వశ్చన్. వాళ్ళందరూ ఏంటంటే ప్రాపర్టీ ఉందని తెలుసు బట్ దే డోంట్ హ్యావ్ ఎనీ డాక్యుమెంటేషన్ అండ్ సర్వే నెంబర్ తెలియవు, ఏమీ తెలియవు, కానీ ఈ సైట్ మాత్రం నాదేనండి, ఇది మా తాతది అని చెప్తారు. మీరు అప్పుడు మరి అడ్వకేట్ కింద ఆ?
సైట్ ఉంది కూడా తెలియదు.
ప్రాపర్టీస్ ఉన్నాయి బట్
వేరే బోర్డు తెలియదు అంటే అప్పుడు మీరు చెప్పాల్సింది ఏంటంటే ఎక్కడ సైట్ ఉందని ముందు ఒక్క సైట్ లాగండి. వాళ్ళని వాళ్ళు అడిగితే ఖచ్చితంగా ఈ సైట్ అనేది నాది అని ఎక్కడో చోట వాళ్ళు సైట్ చెప్తారు. దాని సర్వే నెంబర్లు ఉండవు, డోర్ నెంబర్లు ఉండవు, ఏముండవు. బట్ మీరు ఆ సైట్కి వెళ్ళిన తర్వాత డెఫినెట్ గా యూ విల్ ఫైండ్ ఈ పర్టికులర్ సర్వే నెంబర్ అని పక్కన అక్కడ మీరు ఇన్స్పెక్ట్ చేయండి. సైట్ ఇన్స్పెక్షన్ ఇస్ మచ్ ఇంపార్టెంట్ ఇన్ పర్టికులర్ ఆస్పెక్ట్. ఇన్స్పెక్ట్ చేస్తే మీకు కొన్ని డీటెయిల్స్ తెలుస్తాయి. ఆ డీటెయిల్స్ పట్టుకుని SROకి వెళ్తే ఆటోమేటిక్గా మీకు వస్తాయి. యూ కెన్ ఫైల్ ఎ థర్డ్ పార్టీ అఫిడవిట్ ఇఫ్ ఇట్ ఈస్ రిక్వైర్డ్.
డైరెక్షన్ ఫ్రమ్ ద కోర్ట్.
సార్
ఇప్పుడు మనం డైరెక్షన్
డైరెక్షన్ అలా కాదు. ఇక్కడ డైరెక్షన్ మీరు సూట్ ఎక్కడ వాల్యూ అవుతుంది, మీకు సూట్ ఎక్కడ వాల్యూ అవ్వదు కదా. మీరు సూట్ ఫైల్ చేయాలన్నా సరే మినిమం డాక్యుమెంటేషన్ రిక్వైర్డ్ కదా.
వన్ ప్రాపర్టీ
ఆ ఒక్క డాక్యుమెంట్ తో ఒక్క ప్రాపర్టీ తీసుకొస్తే దాని మిగతావన్నీ అటాచ్డ్ ఆటోమేటిక్ వస్తాయి. ఎందుకంటే వీళ్ళు ముందు ఒక సర్వే నెంబర్ కావాలి, వన్ డాక్యుమెంట్. నాకు తెలిసింది అదొక్కటేనండి, మిగతా డాక్యుమెంట్స్ నా దగ్గర లేవు అని మీరు కోర్టుని అడుగుతారు. ఎవరైతే డిఫెండెంట్ ఉంటారో వాళ్ళు వస్తారు కదా సార్,
వాళ్ళనే ప్రొడ్యూస్ చేయమనాలి.
దట్ ఈస్ హౌ వీ హ్యావ్ టు సార్. లేకపోతే దొంగ కదులుతూనే ఉంటుంది.
That is a provision in which you ask the other side to produce documents is Order 11 Rule 14. Not interrogate this card. Order 11 Rule 14 is asking the other side to produce documents.
తప్పదు, ఇంకొక ఆప్షన్ లేదు. సో మెనీ క్లయింట్స్ విల్ కమ్ విత్ బేర్ హ్యాండ్స్ saying that I don't have any documentation. We know the property is existing, but we don't have documentation because my documents are there with somebody else in my relations. My documents have been kept as a security purpose. These kind of wordings they come up. చెప్పండి.
వరంగల్ ఒక చోట ప్లాట్ ఉందని తెలిసింది సార్. గుంటూరులో ఎక్కడ ఉందో తెలియదు, ఇంకా ఎక్కడో తెలియదు. వాటి గురించి వివరాలు కావాలంటే
మీరు సేమ్ పర్సనల్ హోల్డింగ్ ఎవరైతే ప్రాపర్టీ హోల్డర్ ఇస్ సేమ్ ఆర్ దే హ్యావ్ ఎనీ డిఫరెన్స్? ఎవరు డిపెండెంట్ ఇద్దరు ఉంటారా, ఒకళ్ళు ఉన్నారా? ఇప్పుడు మీరు జూనలాజికల్ ట్రీ మాట్లాడుతున్నప్పుడు అన్నదమ్ములు ఎంతమంది, ఎవరి పేరు మీద మీరు అన్నదమ్ములు అందరూ రాయాలి కదా. డిపెండెంట్స్ విల్ బి దేర్, ఆల్ ఆఫ్ దెమ్. ఒక డిపెండెంట్ కదా మాట్లాడేది. పార్టీషన్స్ మాట్లాడినప్పుడు ఎవ్రీబడి విల్ బి దేర్, ఎవ్రీబడి విల్ రిసీవ్ ద సమన్స్. ఏ డాక్యుమెంట్ అయితే మనం ముందు కంటెస్ట్ చేస్తాం, మిగతా డాక్యుమెంట్ తీసుకురండి నాన్న అని అడుగుతాం. డాక్యుమెంట్స్ పెట్టరండి అని అడుగుతాడు.
సమస్య ఏంటంటే సార్, ఫైల్ చేస్తున్నప్పుడు నాకు వరంగల్లో ఉన్న ఫ్లాట్ గురించి తెలుసు, మిగతా ఫ్లాట్స్ నాకు ఎంత ప్రాపర్టీ ఎక్కడ ఉందో తెలియదు,
ఎవరికి
తెలియదు. కానీ డౌట్ ఏంటంటే ఎక్కడ ఉంది మొత్తానికి, ఇంకా చాలా ఉన్నాయి.
సార్ ఇప్పుడు
ఇంకా అడగొచ్చు మీరు.
ఇప్పుడు అదే చెప్తున్నాను, ఒకళ్ళు అయితే ఫైండ్ అవుట్ చేస్తారు కదా. ఇప్పుడు మీకు ఎంతమంది అన్నదమ్ములు, మీరు అడిగిన చూడలేదు ఎంతమంది అన్నదమ్ములు? మీరు ఒక్కళ్ళు ఉంటే ఒకళ్ళు, డిఫెండెంట్ నలుగురు ఉంటారు, కానీ ప్రాపర్టీ ఒకటే మీకు ఫైండ్ అవుట్ చేశారు. మిగతా ముగ్గురిని కూడా పార్టీ చేయండి.
తప్పదు. పార్టీషన్ ఉన్నప్పుడు అందరిని ఇంక్లూడ్ చేయాలి. అండ్ యూ కెన్ ఆస్క్ ద కోర్ట్ టు డైరెక్ట్ దెమ్ టు ప్రొడ్యూస్ ద డాక్యుమెంట్స్. సో ఇన్ సో ప్లేస్లు ఉన్నాయని
In this regard, you can go to the MRO's office. There they maintain the village records. In the village records, the survey number 91 or 92. ఎవరు పేరు మీద హాని ఉంది, ఎవరు దాన్ని ఆక్రమణదారు, దాని పట్టదారు ఎవరు, ఎంత విస్తీర్ణం ఎంత, దాని సరిహద్దులు ఎంత, మీకు అక్కడ మీకు MRO ఆఫీస్ దొరికిపోతుంది. Then suppose you want to know whether any మైఫోస్ కౌల్దార్ రక్షణ కౌల్దార్ ఉంటే RDO ఆఫీస్కి పోయేసి they maintain a register called 38D register. In the 38D register, the entire entries will be made. What are the properties under which the protected tenant is existing? What is the extent of that land? What are the boundaries of that land? What is the description of that land? You find it in the RDO's office. And suppose you want to find out regarding the immovable property, then you have got what is called RTI, or what is called right to information. From that, they liaise on your behalf and get you the particulars. It's as good as a proper document. The question is, here because since we have dealt with the digital office application, there are 3 stages. Suppose you want urgent orders from the court, you file an application called out of order. Out of order, that is under section 151 CPC you file. Then, along with that, You ask for what is called first and foremost is in the interlocutory application what you file, you don't mention it as permanent injunction. You only say temporary injunction may be granted. And one more important precaution you have to take is the schedule of the property has to be clearly mentioned. Unless you mention the schedule properly, you cannot get a proper order. Then Sariyadul, that is the boundaries also have to be given. Then the question is the schedule which you file also has to be verified by your party, saying that the schedule and the boundaries mentioned are true and correct. Are you able to understand this? Then there are two things you have to remember. I think there are two types of documents. One is called suit document and another is called evidentiary document. Please remember now that CPC has been amended, commissioners are appointed for the purpose of recording the cross-examination. I'm sorry to say that the commissioners have no knowledge as far as what is meant by suit document and what is meant by evidentiary document. The Evidence Act says suit document means it is a foundation of the claim which is made before the court, and all original documents or certified copies will have to be filed along with the suit. Suppose you take a money suit, you have a promise and note. Promise and note is supposed to be the suit document. That is the foundation of your claim. Then legal notice, so on and so forth. But there are some correspondence between you and the opposite side, which admits and acknowledges the liability. That is called evidentiary document. So suit documents will have to be filed along with the suit. You cannot file it later. Unless you resort to Order 7, Rule 14, bracket 2, under the Civil Procedure Code to admit those documents.
ఇక్కడే ఉన్నాడు హిందూ సక్సెషన్ యాక్ట్ లో ప్రైమరీ ఎగ్జాంపుల్ ఈయన కూడా అడ్వకేట్ గుంటూరు ఈయనే పెద్ద ఎగ్జాంపుల్ ఇప్పుడు సార్ ఎగ్జాంపుల్ చెప్పండి సార్ లైవ్ ఎగ్జాంపుల్ ఇక్కడే ఉన్నాడు హిందూ సక్సెషన్
And I am his advocate.
సార్ చెప్పండి ఏం పర్లేదు నర్సరావుపేట కేసు హిందూ సక్సెషన్ యాక్ట్ ఇట్స్ లైవ్ కేసు ఇది.
I'm sorry, I have a bad impression about Andhra courts.
Live case.
Staff especially.
Whatever it's but
లేదు
learn the things.
నో
We are
Proper
unlearning,
గా
we are unlearning so many things there.
మీరు ఇప్పుడు ప్రొసీజర్ ప్రాసెస్ తెలియకపోతే కోర్టు స్టాఫ్ గాని జడ్జి గాని ఏ విధంగా రెస్పాండ్ అవుతారు అన్న విషయాన్ని క్లియర్ ఎగ్జాంపుల్ ఈజ్ సూట్.
తెలియాలి సార్, తెలియకుంటే మనము
ఈమె సూట్ పెండింగ్ లో ఉంది, స్టిల్ గోయింగ్ ఆన్. ప్రొసీజర్ ప్రాసెస్, ఎస్ఆర్ నెంబర్స్, ఫైలింగ్ డేట్స్, ఇక్కడ మన ఎస్ఆర్ అంటే అక్కడ సిఎఫ్ఆర్ నెంబర్, ప్రతిదీ ప్రాసెస్ లో వెళ్లాల్సిందే, ప్రొసీజర్ ప్రకారంగా వెళ్లాల్సిందే. ఎందుకంటే ఐఏ వేస్తున్నారు, ఒక ఇంటర్లాక్యుటరీ అప్లికేషన్ వేస్తున్నారు అంటే అది లిమిటేషన్ లో ఉందా, లిమిటేషన్ లో లేదా అన్న విషయాన్ని స్క్రూటినీ చేసి ఎస్ఆర్ చేయించాల్సిందే. లేకపోతే ఈయనకి ఆల్రెడీ ఒక ఎస్ఆర్ వేస్తే అసలు ఐఏ నెంబర్ అయింది కానీ లిమిటేషన్ లో లేదు, రిటర్న్ అయింది 2 ఏళ్ల తర్వాత, 2 years రిటర్న్ అయింది, అయ్యే నెంబర్ చేశారు, రిటర్న్ చేశారు. అంటే ఒక ప్రొసీజర్ రెండు తెలియకుండా కొన్ని విషయాల్లో కొంతమంది స్టాఫ్ జాప్యం ఉంది. ఐ మీన్ టు సే దేర్ ఇస్ అ నెగ్లిజెన్స్ దేర్. సో ద నెగ్లిజెన్స్ ఇస్ క్రియేటింగ్ ఎ హవాక్ ఇన్ హిస్ సూట్.
స్టాఫ్ కి కూడా కొంత
నాలెడ్జ్ ఉంటుంది. కాదు ఇక్కడ వాళ్ళకి ఏమవుతుందంటే వాళ్ళు వచ్చి వాళ్ళకు కూడా బండిల్స్ ఆఫ్ వస్తున్నాయి. ఆ వచ్చినప్పుడు ఓవర్లుక్ లో చేస్తారు. ఏ డైరీ కానీ ఖచ్చితంగా అయ్యే లిమిటేషన్ లేదు. కానీ వీళ్ళు పర్టికులర్ అయ్యే వేశారు ఈ దాంట్లో, అది లిమిటేషన్ అయిపోయింది. లిమిటేషన్ కి మీరు మాట్లాడిన రివ్యూ పిటిషన్ ఉంటుంది.
We have had an exhaustive discussion on Hindu Succession Act. Here, what are the forms you file when you file a suit? Here, as far as suit on the original side is concerned, it is not normally numbered in the civil court as OS. Previously, when we were in the residency town of Chennai, it used to be numbered as CS, civil suit. They number it as OS. That is suit on the original side. is what is called AOS. Then what you file, the question is, when you file process, I think most of you know, in Telugu they call it as bata, or bata. Then along with that, when you file a civil suit, you are supposed to file it in triplicate. The forms you have to complete in triplicate. Then summons for settlement of issues, that is under Order 5 of Civil Procedure Code. Then you have to pay process through court as well as registered post initially. Because by registered post also you have to pay the summons. Then when you are asking for interlocutory order, you will have to ask for file what is called notice to show cause bracket general IA form, that is to serve it on the other side. Then as many copies as there are parties, you have to supply those number of copies. And then as many documents as you have filed, you must supply a copy of the document to the other side. That is, it is absolutely mandatory. Then under Rule 125 to 127 of the Civil Rules of Practice, suppose you don't supply the copies, suppose the suit is numbered, the other side can file a memo under Rule 125. Sir, the other side has not furnished me the copies, kindly direct the other side to furnish me copies. Then suppose you don't furnish the copies, under Rule 126, the court passes directions. Even after that, you don't supply copies, under Rule 127, your documents will be rejected. Are you able to understand this? Then you file the process form, that is Form 61. Along with that, if it's an original suit, you file settlement of issues and you ask for interlocutory orders. Then you file notice to show cause general. As many parties are there, you will have to furnish those copies also. Along with that, the material papers also you have to file. I'll deal with it in detail when I come to Civil Procedure Code. We are just intermingling between the Succession Act as well as Civil Procedure Code. The next aspect is, this is as far as in brief. Of course, I'm not saying exhaustive. In brief, the Hindu Succession Act. If you want it in detail, I deemed it on YouTube, on Dharma Legal. You can just go through it so that you'll have a clear impression about it. And still, if you want the procedure that is followed in civil court, I have written a book on Key to Civil Procedure Code, giving you the formats of different types of suits and also what are the forms you file along with the suit. You can go through it. Because the time that is available to us is very, very minimum. I have to devote on the other two subjects also. That is the reason we wind up with Hindu Succession Act. Anyone has got any doubts or any clarification, you are free to ask.
So you said the family member certificate is more acceptable.
They are not accepting it.
Family member certificate acceptable only on the government if the particular person is the government employee. Who is the deceased? Deceased is a government employee, central government, state government, ఈ రెండిట్లో ఉంటేనే ఆర్ a banker, so called ఇప్పుడు PSU banks లో deceased person అలా అయితేనే కనుక it is applicable.
But
Otherwise,
as far as family member certificate is concerned, as a bank advocate, I reject those documents. I don't accept.
ఎవరికి ఫ్యామిలీ మెంబర్ సర్టిఫికేట్ చెప్పి గవర్నమెంట్ రిటైర్డ్ ఎంప్లాయీ
వాళ్ళకి పని చేస్తుంది సార్.
వాళ్ళకి మాత్రమే,
మనం పని చేయాలి.
ఓన్లీ గవర్నమెంట్.
అది కూడా not for other purposes. It's only to recover the
చెప్పండి.
terminal benefits.
వాళ్ళు ఎప్పుడైతే ఫ్యామిలీ మెంబర్ సర్టిఫికేట్ ఇస్తారో దానికి ఒక నెంబర్ ఉంటుంది. దాని నెంబర్ బట్టి మీరు ఫైండ్ మళ్ళీ ఇవ్వరు.
ఫ్యామిలీ మెంబర్ సర్టిఫికేట్ 2006 కన్నా ముందు
We are one by one.
Per capita, per stripes, distribution of the property.
అది practice you have to work out.
What is per capita and what is per stripes?
ఫ్యామిలీ మెంబర్ సర్టిఫికేట్ మిస్ అయితే సర్టిఫికేట్ కాపీ అక్కడ
సర్టిఫికేట్ కాపీ ఇస్తారు. యూ హ్యావ్ టు గెట్ మీ దగ్గర ఒక కాపీ ఉండాలి.
ఈ పట్టా ఇవ్వరు.
సార్ ఇక్కడ
జిరాక్స్ కాపీ పెట్టారు సార్.
ఎవరు
అదర్
ask him the original to be produced in front. Original miss avutha they can take from e-seva. Anybody certificate copy తీసుకోవచ్చు మీరు.
Or you can summon it from that authority whichever has given that
they're not issuing.
They will issue it. There is no other way.
say one thing is this, we have to the best of my ability I have covered all the aspects and more emphasis was on women's rights. And Hindu Succession Act acquires lot of importance.
చెప్పండి.
With regard to the Hindu Succession Act, I said in it was when the father-in-law has within certain amount of property, and he has declared only probably just one property out of all the properties in court, saying that I only own this property, and he does not want to give it to his daughter-in-law whose husband has passed away. So those were his intentions. So we were just discussing about the site inspections and all the problems. And even probably seeking information from the registrar. The registrar does not have a habit of providing the details generally because of that we have a lot of work to do.
The question is, in that contingency, you try to summon the concerned authority to produce those documents to the court.
Until unless we have the document number, how can we do it?
No, question is, you must have the document. You must be having the document number.
The problem is that
See,
in
this case,
the properties are very.
in this case, I just referred to Hindu Law of Adoptions and Maintenance Act. There is a clear judgment of the Supreme Court or Punjab and Haryana High Court. It says it's a duty of the father-in-law to maintain the widowed daughter-in-law according to his resources and according to the availability of funds. He cannot absolve himself of his liability to maintain a widowed daughter-in-law who is depending on the family. Then the question is, the father-in-law has hidden something, then you file a search application before the concerned.
Point is, if the father-in-law has lied in his affidavit with respect to the properties and criminal.
You get income tax returns are also there, sir. In income tax returns, you have got income from house property or income from property. You can get a certified copy from the IT department also.
RTA application.
Yeah, RTA also you can give. See, that's the advantage you people have now. When we studied or when we came to practice, we didn't have all these things.
They can file it from you can file with property tax authorities. Stuff you can file with at least SROs in some places, at least where you.
But the authentic information you get from the income tax department.
Property tax may not be don't give such information.
Let's summon the records. Summon the records.
Sir, any doubts on succession? Yes, please, sir.
Yes, what is the difference between normal will deed and registered will deed?
Sir, there is no difference. There is no difference between a unregistered will deed or a registered will deed. As far as Hindus are concerned, under the Hindu Succession Act, a will deed need not be registered. But one thing is this: the properties which is willed away should be within the disposing capacity of the individual. How he has acquired the property has to be clearly mentioned, and it has to be duly attested by 2 witnesses. So attestation of a will is absolutely mandatory. It doesn't require registration. But as far as the Christian will is concerned, Christian will is supposed to be a testamentary transfer. It has to be registered, and letters of administration has to be obtained as far as Christians are concerned. But as far as Hindus are concerned, registration is optional under section 18 of the Registration Act.
కానీ ఇప్పుడున్న జనరేషన్ లో ప్లీజ్ ట్రై టు మేక్ ఇట్ అట్లీస్ట్ నోటరైజ్ చేయమని మా రిక్వెస్ట్. ఎందుకంటే ఇవాళ రేపు విల్ డీడ్స్ ఆర్ ఆల్సో గెటింగ్ ఛాలెంజ్డ్ ఇన్ నెంబర్ ఆఫ్
రిజిస్టర్డ్ కూడా ఛాలెంజ్ చేస్తున్నారు సార్ ఇవాళ.
రిజిస్టర్ అందుకని అంటున్నాను,
రిజిస్ట్రేషన్ అయిన కూడా ఛాలెంజ్
మనం ఉన్నాం కదా.
అందుకనే
మన ఇంకా అదే
అంటే ఇక్కడ ఒక 2 విషయాలు సార్. ఇక్కడ 2 విషయాలు జరుగుతున్నాయి. రిజిస్టర్డ్ విల్ డీడ్ కూడా ఛాలెంజ్ ఎందుకు చేస్తున్నాడు కూడా చెప్తాను. ఇప్పు, ఇస్సు, బట్టు, ఈజు వీటన్నిటికి కూడా కొన్ని మీనింగ్స్ ఉంటే దోస్ విల్ డీడ్స్ వర్ డ్రాఫ్టెడ్ ఆర్ వెరీ బ్యాడ్లీ డ్రాఫ్టెడ్. ఎందుకంటే మళ్ళీ చెప్తున్నాను, అడ్వకేట్స్ అన్న వాళ్ళు ప్లీజ్ అప్రోచ్ అవ్వండి. మీరు కూడా ఎడ్యుకేట్ చేయండి, టాకింగ్ టు యువర్ క్లయింట్ సేయింగ్ దట్ అలా ఊరినే చేసుకోవద్దు.
అడ్డ మీద పోయి ఆ సైడ్ కు డబ్బాలు ఉండే దగ్గర చేపిస్తున్నారు సార్, దాంతో దెబ్బ పడుతుంది.
ఇప్పుడు జరుగుతున్న విషయం ఏంటంటే చాలా మందికి ప్రాబ్లమేటిక్ గా జరుగుతున్నది ఏంటంటే ఈ సో కాల్డ్ డ్రాఫ్ట్మెన్స్ సిట్టింగ్ డిసైడ్ ఇన్ ద రిజిస్టర్ ఆఫీస్ ఆర్ నాట్ డ్రాఫ్టింగ్ ప్రాపర్లీ. నేను ఒక మాట చెప్తాను. ఇప్పుడు దేర్ ఇస్ అ కేస్ ఇన్ అప్రాక్ రీసెంట్ గా వచ్చింది, which is a deep patta land. Deep patta land. It is given in 1980s. 80s లో వచ్చింది deep patta land. అసలు ఎలినేట్ చేయడం లేదు deep patta land. You cannot alienate any deep patta land. లావణ్య పట్ట చేయడానికి లేదు వాళ్ళకి. ఆయన చనిపోయింది 2018 ఇప్పుడు చనిపోయాడు. పర్టికులర్ డీ పట్టా ల్యాండ్ హోల్డర్ చనిపోయిన దగ్గర ఏం చేశారు 2020లో పార్టీషన్ చేసుకున్నారు. పార్టీషన్ చేసుకుని ఒక పర్సనాలిటీ వన్ ఆఫ్ ది ఐదుగురు ఉన్నారు మొత్తం సంతానం. 5 సంతానంలోనూ 5 పార్టీషన్ రాసుకుంటారు. అన్నదమ్ముడికి ఇస్తాను నేను అని చెప్పి ఆడపిల్లలకి చెప్పారు మప్పి పెట్టారు. డబ్బులు ఇవ్వలేదు కదా, వాడు ఏం చేశాడు రాత్రి వాడి షేర్ వాళ్ళకి అమ్మేసి నిలిపాడు. నౌ యూ టెల్ మీ వాట్ ఈస్ ద కేస్ వీ కెన్ ఫైల్ ఆన్ దట్?
No, sir, I'm sorry. In this regard, Succession Act Prohibition of Transfers Act of 1977, the concerned section is Section 3. It says a landless, any land that is assigned cannot be alienated with
without the government permission.
There is a exception to that. 3/5 undi. And a landless poor can alienate to a landless poor, right? And who is a landless poor? Anedi, a person who does not hold more than 3.5 acres of wetland and 5 acres of dry land. That's how it has been defined. So a landless poor can transfer it to a landless poor. Number one. Number two, the restriction that is imposed under the Act 9 of 1977 says that for a period of 10 years that bar will apply. After 10 years, you can formally address a letter to the collector to alienate the property. You can do it after 10 years. No one stops you from doing it. And even our Ramoji Film City, Abdullapur Met is also assigned land.
వేరే వాళ్ళకు కూడా లేదు. ఇప్పుడు అసైన్ ల్యాండ్ ఏంటంటే ఇంత ముందు రాజీవ్ గాంధీ ఇందిరాగాంధీ టైంలో కొన్ని అసైన్ ల్యాండ్స్ ఇచ్చారు పూర్ పీపుల్. బట్ ఇక్కడ జరుగుతుంది ఏంటి, మీరు అన్నట్టు ఛాలెంజ్ చేయగలమండి. ఎస్ వీఆర్ ఛాలెంజింగ్ ద సేల్ డీడ్. నవ్వు ఎలినేట్ చేసాడు, ఒక పర్సనాలిటీకి అమ్మేశారు. పెద్ద అద్భుతం అని చెప్తా. అంటే మేము ఎందుకు డాక్యుమెంట్స్ మన్ను పెట్టుకోవాలి నేను అడుగుతున్నాను. అడ్వకేట్స్ హైర్ చేయండి అని మేము రిక్వెస్ట్ చేస్తున్నాం. చెప్పింది ఏంటంటే ఎందుకు చేసామంటే ఇక్కడ వాడు ఒక అద్భుతమైన పార్టీషన్ డీడ్ చేశాడు బిట్వీన్ ద పీపుల్. స్మార్ట్ కూడా కాదు సార్ అది, దాని స్మార్ట్ అంటారు సార్. ఏ విధంగా స్మార్ట్ అర్థం కాలేదు. అసలు పార్టీషన్ చూస్తే ఓన్లీ హౌస్ నెంబర్స్ ఆర్ దేర్, నాట్ ఈవెన్ సర్వే నెంబర్, నాట్ ఈవెన్ డాక్యుమెంట్ నెంబర్. మాకు డీ పట్టా ల్యాండ్ తాలూకు ఒక పేపర్ చూపించాడు. నథింగ్ ఈజ్ విజిబుల్. ఇదొక ఆస్పెక్ట్ మాట హిందూ సక్సెషన్ లో కూడా. ఎందుకంటే అది చూసుకోవాల్సిన అవసరం కూడా మనకు ఉంటుంది. నామినల్ ఫీచర్ ఒకటి తయారు ఎక్కడి నుంచి తాతల నుంచి ఎవరికి వచ్చింది ఇదంతా కూడా లేదు. డైరెక్ట్ పార్టీషన్ ఎలా చేశారు ఎవరికి చెప్పండి సార్.
వేరే వాళ్ళ కొనుక్కున్నారు 1980లో. అప్పటి నుంచి స్టేయింగ్ ఈజ్ ద విడౌట్. ఓకే, పిల్లలు లేరు, ఎవరు లేరు, ఒక్కటే ఉంటుంది. ఇప్పుడు 75 years. ఓకే, ఇప్పుడు తను షేర్ చేయొచ్చా, ఎవరికైనా డిస్ట్రిబ్యూట్ చేయొచ్చా?
ఎలా చేస్తారు? పిల్లలు లేరని ఎలా నేస్తున్నారు?
లేరా?
పిల్లలు లేకపోతే వాళ్ళ తాలూకు ఫాదర్, మదర్ అండ్ వాళ్ళ చనిపోయిన భర్త తాలూకు వాళ్ళ ఫాదర్, మదర్ లేదా వాళ్ళ అన్నదమ్ముడు ఇంతమంది ఉన్నారు. 75 కదా సార్, 100 ఏళ్ళు ఉన్నా సరే విత్ ఇన్ ది ఫ్యామిలీకి ఎవరో ఒకళ్ళు నీళ్ళారు ఉంటారు. వాళ్ళకి ట్రాన్స్ఫర్ అవుతుందా తప్ప యూ కాంట్ ట్రాన్స్ఫర్ ద ప్రాపర్టీ టు ఎనీవన్. ఆమె చేయడానికి ఎవరు అమ్మడానికి లేదు. ఇందులో 2 విషయాలు అన్నారు. 1978 లో డీ పట్టా ల్యాండ్ వస్తే ఎలినేట్ చేయడానికి ఛాన్స్ ఉంది విత్ సర్టన్ క్లాసెస్ అగైన్. మళ్ళీ 1982 తర్వాత డీ పట్టా ల్యాండ్స్ కొన్ని వచ్చాయి. 82, 84, 85 అవి ఎలినేట్ చేసే అవకాశం ఉంది. అంటే ఒక పర్టికులర్ లిమిటేషన్ ఇచ్చారు. కలెక్టర్ ఉండదు. ఖచ్చితంగా కలెక్టర్ అప్రోచ్ అవ్వాలి. నేను ఎలినేట్ ఎవరికి చేస్తున్నానో చెప్పాలి, ఎందుకు చేస్తున్నానో చెప్పాలి. ఇన్ని వివరాలు అందరూ పెట్టాలి, కన్ఫైన్ చేసుకోవాలి.
సార్ ఒక సిచ్యువేషన్ లో యాక్సిడెంట్స్ కాంప్లెంట్స్ ఎవరు లేకుండా ఒక ఫిమేల్ విడో ఉన్నది, ఎవరు లేదు. అలాంటప్పుడు
హకీంపేట ఎయిర్పోర్ట్ దగ్గర ఒక ల్యాండ్ ఉంది, పెద్ద ల్యాండ్ 2.5 acres ల్యాండ్ ఉంది. డీ పట్టా ల్యాండ్ అంటున్నారు. అది ఇప్పుడు ఎటు కాకుండా అలాగే కూర్చుంది.
రిజిస్ట్రేషన్ అయిపోతే తీసేసుకోవచ్చు సార్.
డాక్యుమెంట్ క్యాన్సిల్ చేసే పవర్స్ కూడా ఉన్నాయి సార్.
గవర్నమెంట్ కేసెస్ క్యాన్సిల్ అవుతుంది.
Chalo. Now we turn out to next. Or anybody needs a break? Or is it fine?
We have a break of 10 minutes.
నెక్స్ట్ బ్రేక్ తీసుకుందాం సార్.
Next తీసుకుంటారా?
లంచ్ బ్రేక్
లంచ్ బ్రేక్ తీసుకుంటే జనాలందరూ ఎగిరిపోవడానికి రెడీ అవుతున్నారు. లేదు.
అదే
ఎందుకంటే CPC will be in the end.
CPC ముందు పెడితే వెళ్ళిపోతారు.
No, specifically.
See, one more thing I remind you, sir. In Dharma Legal, I've discussed every aspect of it. You can just go through the YouTube. It will enlighten you on that.
ఇక్కడ మళ్ళీ ప్రాస్పెక్ట్స్ ఏమొస్తుందంటే ఏ డాక్యుమెంట్స్ చేయాలి, ఫైలింగ్ ఎలా చదవాలన్నది కూడా వీఆర్ కమింగ్ అప్. అంటే చాలా మంది స్టూడెంట్స్ కూడా ఇప్పుడు సమ్ ఆఫ్ దెమ్ హావ్ కమ్ ఆల్ ది వే ఫ్రమ్ స్టూడెంట్స్ హావ్ ఆల్సో కమ్. బట్ స్టిల్ మన ప్రాక్టీసింగ్ అడ్వకేట్స్ కూడా కొంతమందికి కొన్ని విషయాలు తెలియదు. అన్నీ తెలియాలని అనట్లేదు. వీఆర్ ట్రైంగ్ టు ఎడ్యుకేట్ దెమ్ ఆల్సో. విత్ పేషెన్స్ ప్లీజ్.
We'll have a break of 10 minutes.
Just sir.
If anybody has a doubt, you can clear up. If
I
you
break.
10 minutes break, you can clear up the doubts here. By saying,
Sir,
sir, streaming లోనే ఉంది, మీరు మాట్లాడొచ్చు. You can have it.
సక్సెస్ చేసి
కొంచెం లౌడ్గా చెప్తే మాకు కూడా
నేమ్ తో కానీ సర్టిఫికేట్
I can take this.
సో ఏదైనా కూడా మనకి ల్యాండ్ సర్చ్ కానీ లేకపోతే ప్రాపర్టీ సర్చ్ కానీ చేయడానికి మన తెలంగాణ ఆంధ్ర స్టేట్లో సైట్ రూల్స్ దాంట్లో అడ్రస్ పేరుతోని సర్వే నెంబర్